Hi aspirants, welcome to the weekly roundup of Polity and International Current Affairs Part 2. Last time we skipped one video because of the lockdown and holidays issues, and I said we'll be giving a Part 2 video, and this will be the Part 2 video of it. The first topic for today is recognition and derecognition of political parties. The registration of political parties is governed by the provision of Section 29A of the Representation of the People Act of 1951, a prelims point. And why this is in news? Because a petition has been filed in the Supreme Court asking the Election Commission of India to seize the election symbol or deregister a political party, any political party that comprises or promises to distribute irrational freebies from public funds before election, because we know this has become a fashion nowadays. Before election, political parties, they just promise irrational freebies. We'll give everything free for you, and people who get attracted by this, they cast their votes, least knowing that it's their money that has been used, even if that freebies are actually given. Now, getting into the conventional part of this, any party seeking registration under the said section within the Election Commission of India have to submit an application to the Election Commission of India within a period of 30 days from the date of the formation of this particular party. Once a party is formed, it can have two different status, either an unrecognized party. Even if it is recognized later on, it could become a national political party or a state political party only if it satisfies certain conditions. Let us see the conditions for a party to be recognized as a national political party. We say national parties, right? For example, the Congress, the BJP, these parties are called as national parties. While in Tamil Nadu, state parties are, for example, AIDMK is a state party, DMK is a state party, so on. So, to get the status of a national political party, there are certain conditions. So, condition 1, where at least 6% votes in any 4 or more states. Okay, it should be, they cannot get, say, all the 6% of votes in the Lok Sabha from just one state. For example, a state as big as Uttar Pradesh can be done this. Okay, but the votes have to be distributed in 4 or more states for the Lok Sabha or the state legislative assembly, anything, whether it could be the Lok Sabha or the state legislative assembly. So this is one. And also it should win 4 seats in the House of People. In our case, if it's a central government, it is the Lok Sabha, or in the state government, it's the legislative assembly. So the conditions are 6% of votes in 4 or more states in Lok Sabha or legislative assembly, and 4 seats in the Lok Sabha or the assembly. So this condition is common for Lok Sabha and the state assembly. So the numbers are 6 and 4. Okay, this is the key, 6 and 4. And if not, there is another condition, or it wins 2% of seats in the Lok Sabha, and these members should be elected from at least 3 different states. So here we are not talking about the percentage of votes, but percentage of seats. In the case of percentage of seats, 2% of seats are enough, and these seats should be elected from 3 different states. Or there is a third condition also. If simply a particular party has been recognized as a state party in 4 states. Now, for example, let us say in Tamil Nadu we have DMK, we have ADMK, the most famous state parties. Can they be called as national parties? No, because they are recognized as state parties in Tamil Nadu and maybe sometimes in Pondicherry. That's all. They are not recognized as a state party in 4 states. So this condition does not satisfy. And next one, what are the conditions for a for a political party to get the status of a state political party? So condition number 1, at least 6% of votes in the legislative assembly, and along with that 2 seats in the legislative assembly in that particular state. For example, if a political party wants to become a state political party in Tamil Nadu, it has to get 6% of votes, and along with that 2 seats in the Tamil Nadu State Assembly. Or if not this condition, they can satisfy another condition. If it gets 6% of votes in the Lok Sabha elections in that particular state, that is, for example, if it is Tamil Nadu, in the Lok Sabha election from the Tamil Nadu constituencies, it should get 6% of votes, and along with that, it has one seat in the Lok Sabha from that particular state. In our example, if a party from Tamil Nadu wants to get the status of a political party, state political party, it can get 6% of votes in the Lok Sabha election from Tamil Nadu. Along with that, one Lok Sabha seat from Tamil Nadu. Or there is another condition. If it wins one seat in the Lok Sabha for every 25 seat or any fraction such that, okay, so for every 25 seat, it wins one seat. Directly it becomes a state political party. Another condition is also there. Or there is another condition. If it secures 8% vote in the Lok Sabha or the legislative assembly of that state, okay, simply nothing, no condition at all. If you are able to get directly 8% votes, you are not concerned about the number of seats, nothing. It can be anywhere, either in the Lok Sabha or in the state assembly. If you are able to get directly 8% votes, because we know getting around somewhere around 33% of votes means that you can form the government. That's how political parties are winning nowadays. And sometimes in the case of coalition, the number of the percentage of votes are even lesser than 33%. So getting 8% of votes means that it's a strong party there. So directly it can become a state political party. And important thing here, a confusing prelims question could be, this condition was introduced only in 2011. So we have 3 conditions for national political party and 3 conditions for state political party, and one more condition was introduced for the state political party in 2011. So now, if a party becomes a state political party or a national political party, what is the benefit of it? There are so many parties. Simply in Tamil Nadu itself, there are so many parties which don't get even 1% of votes. They are also existing. But what is the special benefit in becoming a national political party or a state political party? One thing, their symbol becomes reserved. You know, those parties which don't get any of the status, every time an election comes, they'll be getting a new symbol. Their symbol is always not the same. Okay, but if they are able to get the status of any of these 2 things, national or state political party, their symbol is reserved. For example, in Tamil Nadu, for DMK, the symbol is always the same. For ADMK, the symbol is always the same. It does not change. For BJP, for Congress, the symbols are always the same. They never change, right? Because they have the status of either national political party or state political party. And the second benefit is they need just one proposer for filing the nomination. That is, if you want to go and file a nomination to contest in the election, you just cannot go and file an proposal there. You cannot go and file a nomination. Some people have to nominate you. They have to propose you. Yeah, I know this person. He belongs to my area. Okay, I'm okay with him contesting in the election. Few people have to propose for you. But in the case of a national political party or a state political party, a member from that party wants to nominate for the election. Just one proposer is enough. That's all. And whenever there is a revision of the electoral rolls, 2 sets of electoral rolls are given free without any cost. That is one more thing. And 1 copy of electoral roll is given to that candidate during every election. And they can advertise about their nominations, their election promises, all these things in the government media, that is Akashvani radio or the Doordarshan TV. The time will be allocated for them. For free they can do this. And one more thing, the travel expenses of star campaigners will not be accounted in the election expense. So this election expense plays a huge role during elections. They cannot spend beyond what the Election Commission of India fixes, but the travel expense of star campaigners will not be counted here. You know, right? So during elections, they bring all actors, actresses and make them speak in the stages, and we people getting attracted by those actors, we go and attend those election manifests as well, right? So for those campaigners, it will not come under the election expense. And the next topic is about criminal justice reforms. So this is in news, not just now, for a very long time. There are many people who have been proposing to make changes to the criminal justice reforms, to make changes to the criminal justice. And why is it? Because there's a lot of delay in the disposal of cases. We know there are a lot of under trials in the prisons, and it is also said that it is against human rights as well, and all the criminal rules or any codes that we are following are draconian. They are very old. They were just followed in the British times. They are draconian. They were followed during the British times. And the criminal law in India has numerous resources, so it's very difficult. So we have the Indian Penal Code of 1860, we have the Protection of Civil Rights Act 1955, Dowry Protection Act 1961, Scheduled Caste and Scheduled Tribes or the Prevention of Atrocities Act 1989. So many different sources are there. We don't have a single source. And all the sources and all the criminal justice which we are following today, Thomas Babington Macaulay, he is called the father of all this. He was the one, he is called as maybe he is called as the chief architect of the codification of criminal laws in India. Maybe it could be a prelims question. So Thomas Babington Macaulay is said to be the chief architect of codification of criminal laws. He is called as the architect. Since reforms are being proposed, there are certain committees which are being established to look into this, and one such committee is Ranbir Singh Committee. So why are these reforms? For criminal justice, for how the police function. That's all right. So you can remember, you can use this picture to remember. Of course, he is not Ranbir Singh, he is Ranveer Singh, but anyway, he is in police uniform. You can use his photo to remember that. Ranbir Singh Committee, if it comes to the prelims, you can very well know that it is something regarding to police reforms or criminal justice reforms, something like that. And apart from that, we have two other committees also, the Madhav Menon Committee of 2007 and the Malimath Committee of 2003. So these two committees, they are really important for prelims. Try to know them. The next one is disruptions in parliament, and I found certain details. You could use them in your mains exam. So this might be not asked in a prelims question, but you can very well use this detail in the mains exam. So as per the PRS legislative research, it has given a report, and it says in the 15th Lok Sabha that functioned from 2009 to 2014, there were frequent disruptions, and it has resulted in Lok Sabha working only for 61% and Rajya Sabha working only for 66%. And we have said multiple times, when you write your mains exam, it is always good to give reports, the name of the report, the indexes, the values that are given in reports, which will fetch you good marks. So you can use this detail in a mains exam. The next topic is about reservation in promotion. So this is in news because recently the Supreme Court has turned down the union government's plea to do away with the requirement of collecting quantifiable data by the center and the state governments to determine the representation of people belonging to SC and ST while implementing reservation in promotion. Okay, so if you are going to give reservation for promotion, you just don't give it. You have to find the data and you have to show that the representation from the SC and ST communities are very low, so we have to give reservation for promotion. This is how it has to be. But the central government asked the Supreme Court to do away with this. We don't have to find any data, just reservation and promotion can go ahead. But the Supreme Court said no, reservation is good, but there should always be a cap for that. Okay, there should be a restriction for that as well. So only if you find a proper data to show that yes, the representation of SC and ST community is less in any particular government office, then you can give reservation for this. So we have to know certain cases regarding this. The M. Nagaraj case 2006 and the Jarnail case 2018 both gave almost the same verdict, that is the state, that is the country is obligated to collect quantifiable data as per the court's judgment. So as per these two judgments, the country or the government has to find or collect quantifiable data, only then they can go for reservation. And there is some other case, the reservation promotion will be proportionate to the population of SC and STs. This was given in a 1995 judgment by the Supreme Court in the R.K. Sabharwal case, and it should be left to the center and the states to decide on promotional avenues for SC and STs. So in 1995 it said the reservation should be in promotion to the in proportionate to the population. Depending on the population, the reservation should be fixed, and it should be left to the central government and the state government on how much to fix. That is how it was given. But later on, in the Nagaraj case and the Janil case, it said there should be a quantifiable data. So you have to know this important case. And what scenario is followed now in present? Now at present there is a roster system in which every cadre of the government department will be assigned a post required to be filled by the SC and STs. So it is based on the roster system. The roster system was based on the population proportion of the SC and STs. A position in the roster for any reserved group is reached by dividing 100 by the percentage of the quota that particular group has. So let us say the reservation percentage, for example, let us take a number 14%. So you divide 100 by 14. This is how you find the value for the roster system. But UPSC doesn't go to such deep questions mostly, but it's good to know. So what system is followed now? It is the roster system. This you have to know. The next one is publishing identity. So this is actually a huge issue nowadays. Even journalists who have to be responsible enough, news media who have to be responsible enough are doing this. They just publish the identity of common people. They find some news, they publish their photographs, they just publish their house, they take video of their house, their street, everything, and they just publish it. And they are least concerned about what it is going to do about the dignity of that particular person, about the privacy of that person. And maybe the news channel, they just come to the conclusion, this person did something. And what if later the court finds out that person was not at all guilty? And what about the lost dignity and the privacy of that person? So this is a huge issue nowadays, and we have to see what acts are concerned with this. One such act is Protection of Children from Sexual Offences Act 2012. That is, we commonly call it as the POCSO Act, right? And this act very specifically says no identity should be revealed, and to some extent this act is respected. But when it comes to people who are away from POCSO Act, that is who are not children, I don't think so the media is following the restrictions properly. And chapter 5 of the POCSO Act says it shows the procedure for reporting of cases. In case of POCSO, it is very sensitive, so it gives a procedure for just reporting of the cases itself. And section 23, it gives the procedure for media, the most important one which we are talking about now. Section 23 of the POCSO Act gives procedure for the media. The publisher or owner of the media or the studio or photographic facilities shall be jointly and severely liable for the acts and omissions of his employee. You just cannot escape saying that the media is mine, the studio is mine, but my employee just published it. I don't know. You are responsible for your employee. That is what the section 23 talks here. And another act regarding this is the Indian Penal Code of 1860. In this, the chapter 11, it talks about of the false evidence and offences against public justice. So what has to be done in the case you give a false evidence? The printing or publication of the judgment of any high court or the Supreme Court does not amount to an offence within the meaning of this section. So under section chapter 11 of the Indian Penal Code IPC 1860, it is not a punishable offence. If you are publishing any judgment of the High Court or Supreme Court, that is you are taking the news to the people, that's fine. But apart from that, you start giving any false evidences or create any offences against public justice, you could be punished. So the two acts that we saw here include the POCSO Act 2012 and the IPC 1860. So the acts, these two names, you can mention them in mains exam, it will be really useful for you, but the details here could be really needed for you in the case of prelims exams. The next one is contempt of court. We all know what is contempt of court. So you talk something against the court, you humiliate the court, you will be punished for contempt of court. So who can file a case for contempt of court? The truth is anyone can file. If I feel someone is creating disgrace to the court, they are talking bad about the court, I can just go and file a case saying that this person, he is causing trouble to the, he is causing disgrace to the court. This is one thing. And there is another type of contempt of court as well. A court gives a verdict, it gives a judgment, and that particular person who has to follow that verdict does not follow, it just neglects, he just does whatever he wants. Let us say there is a case, someone files suit against a company, and the court gives the verdict, yes, the company is guilty and the company has to give 10 lakh as compensation to a particular person, and let us say the company fails to give that 10 lakh, and that will be a contempt of court. Okay, so if anyone has to file a contempt of court, will the case be taken just like that? No. That is the current affair here. As per section 15 of the Contempt of Courts Act 1971, the permission of the Attorney General or the Solicitor General is needed to go for a contempt of court. If I go and file a case against someone saying that he's doing something like contempt of court, I have to get the permission of Attorney General or Solicitor General. Only then that case will be admitted. So why is this done? Because to reduce the burden of the court. Okay, because it can in front of the Supreme Court it has to go. Supreme Court has already so much jobs to do. So many cases are already piled up. So if each and everyone goes and starts to file contempt of court cases, it's going to be a huge burden. So to find out whether that case is valid to be taken, Attorney General and Solicitor General's permission is really needed. And this act, Contempt of Courts Act 1971, it says there are two types of contempts. One is civil, another one is criminal contempt. So what's the difference? The civil contempt is what I told you. Someone related to that case, they don't just follow the verdict of the court given. The court says you have to go to this particular police station and give your signature every day, and he does not do that. That is contempt of court, which is civil. So what is criminal contempt? You talk bad about the court, you talk bad about a particular judge. So that is why mostly you would have seen any question asked to any politician or any people about the verdict given by the court, they'll be very careful enough. They'll say the court has given a verdict, we respect the court. So it's because it is a really sensitive issue. If they talk something unruly against the judgment given by a judge or against the judge or against the court, they could be filed for criminal contempt. But at the same time, if someone goes against the court, if someone commits contempt of court, can the court itself take that case? Yes, absolutely. They don't need any permission from Attorney General or Solicitor General or anyone. The court can by suo motu take a contempt of court case by itself, and this is from the Article 129 of the Constitution. So the prelims question here could be like, the contempt of court is a constitutional provision or not? In such question you have to be very careful. For a suo motu contempt of court, yes, it is a constitutional provision, yes. But for a normal contempt of court, for any normal private citizen to file a case of contempt of court, it is not a constitutional provision. It is a statutory provision from this Act of 1971. So these details you have to know. The next topic is about District Good Governance Index. So this is new. We know Good Governance Index is already there, but it is for the state governments. But something new has been introduced now, that is District Good Governance Index. So it goes by district wise. In every district, in every single district, you check the governance and you give a ranking for that. You give a rating for that. Okay. So this is prepared by the Department of Administrative Reforms and Public Grievances, DARPG, in partnership with the Union Territories Administration, that is Jammu Kashmir's administration. So the important point here is DARPG. So all the policies, schemes, programs of the central government and the state government have been monitored at the district level to give this ranking. And something to be noted here is Jammu Kashmir is the first state where this District Good Governance Index has been introduced. This is the first state, and there are plans to expand this to the other states throughout India later on. But for now, Jammu Kashmir is the only state which has something called as District Good Governance. And please remember, it is not the Niti Aayog which is taking care of this. It is the DARPG and the Union Territories government. And the next one is the Indira Savne case, which is always in news every year. This case happened in 1992. Why I say this year specifically? Because you will know. A 9-judge bench in this famous Indira Savne case, which is also called as the Mandal Commission case, it imposed the ceiling of 50% on total reservation. So you give any sort of reservation for the SCs, for the STs, for the OBCs, or whatever reservation you give, but it should be capped at 50%. Reservation does not go beyond 50%. The rest 50%, it should be for the general category. This was the verdict in the Indira Sawhney case of 1992. So in this case, the Supreme Court said, yes, it is accepted for the 27% quota of the backward classes, because until then, you know, before the Mandal Commission, there was something called as the Mandal Commission. That is what recommended for a reservation for the backward classes also. So when reservation was given for backward classes, that is for 27%, the court said, okay, that's accepted, no problem. But there was another reservation also given, that is 10% reservation was given for government jobs for economically backward classes. This was struck down by the court. The court said, no, this is not acceptable. But this 27%, yes, it is acceptable. So this is the Indira Sawhney case. And this Indira Sawhney case also introduced something called as the creamy layer. We know there is something called as creamy layer for the OBCs. That is, for the OBC community, if they are in a very high posting like group A or group B postings, and if they are going to earn more than 8 lakh rupees, and such conditions are being laid down, under such conditions the OBC community people will not be eligible for reservation, and those people are called as creamy layer. And this creamy layer concept was introduced in the Indira Sawhney case. And moreover, the Indira Sawhney case also said reservation will be only for initial appointments and it cannot be extended to promotions. And be very clear on this, this is only for OBCs, because just now we spoke about there is a reservation for promotions regarding SC and STs, but according to Indira Sawhney case, there will be no reservation for promotions, only for OBCs. Okay, you can give initial appointments in reservation, but no reservation for promotions. And something to know more about this, later in the 77th amendment of 1995, so Indira Sawhney case was in 1992, we know that. So in the 1995 77th amendment, a new article called 16 clause 4a was added. We know the article 16 is for giving reservations, and under this 16 article 4a was added. According to this, the government was empowered to give reservation to SC and ST employees for promotion. So for promotion, reservation can be given for SC and ST employees, and this is under article 16 clause 4a. This article is important, and this amendment is important for prelims. And now I told you to remember the Indira Sawhney case, the year is 1992, and this is because it is here. Tamil Nadu has something special. And as soon as this 1992 Indira Sawhney case verdict was passed, before that, in Tamil Nadu, the then Chief Minister of Tamil Nadu, the late Miss Jayalalitha, she had given reservation for OBCs in the name of MBCs, and that crossed the limit of 50%, and it went up to 69%. But now the Indira Sawhney case says reservation have to be capped at 50%. So what she did, she passed a new act saying that Tamil Nadu backward classes, scheduled caste and scheduled tribes reservation of seats in educational institutions and appointments or posts in the services under the State Act. So she passed this act in 1993 to keep the reservation limit intact in 69%. Though there was an verdict given by the Supreme Court, she passed an act from the state saying to make it possible that the reservation will stay at 69% and it is not made null and go back to 50%. And this act was passed by the Parliament also in 1993. So Parliament gave assent. And what she did, something else. She took this act. She took this particular act and she kept it in the 9th schedule through the 76th Constitution Amendment passed by the Parliament. So this act, it was just a state act, but she took the 9th schedule and she took this particular state act and put it in the 9th schedule, and but that has to be going through a constitutional amendment. And yes, the Parliament passed that constitutional amendment also in 1994. So it starts in 1992, the State Act in 1993, and the Approval Parliament Act in 1994, and then another amendment in 1995. So it starts in 1992 and it goes up to 1995. And I hope you remember regarding this 9th schedule, later certain verdicts were given saying that just because you put something in the 9th schedule, it doesn't mean that it does not have judicial review. It will have judicial review. So this we know already. Okay. And after this, to make this stronger, some more amendments were passed. So we said about the 77th amendment already, and we also spoke about this 76th amendment. So we already have the 76th amendment and 77th amendment. Then we have this 81st amendment. This included article 16 clause 4b. We know the 77th amendment added clause 4a, and the 81st amendment included clause 4b, which says unfilled SC and ST quota of a particular year, when carried forward to the next year, it will be treated separately and not clubbed with the regular vacancies of the second year. Let us say at first year there are 2 seats which are not at all filled, which belong to a reserved seat, and in the next year there are some 15 seats. This 2 seat will not be included to this 15, but it will be added to the next seat and it will become 17 seats. So this is what the 81st amendment said. And then the 85th amendment act of 2001, this act said reservation in promotion can be applied with the consequential seniority for the government servants belonging to SC and ST with the retrospective effect from June 1995. So the act is passed in 2001, but they said this act will be applied for everyone from 1995 itself. This act was retrospective. So this is again important. So they said the retrospective effect will be there. For this retrospective is you pass the act today, but the act will be effective for something which is happening since earlier. Okay, so the act is passed here in 2001, but they say they'll take all the details since 1995 also and they will apply it. So the act is applied for the past. So the such acts will be called as retrospective acts. So now we have the latest one, the 103rd amendment of 2019, which gives 10% reservation for EWS, because we already know Indira Savane case said there cannot be 10% reservation for EWS, but by the 103rd amendment it was again broken and we have 10% reservation for EWS. But how was it passed? Because there is already a verdict in the Indira Savane case. 10% reservation cannot be given. So the 10% reservation for the EWS was given very carefully, that it does not cap the 50%. So it does not breach the Indira Savane case. And we have this article 335. It says claims of SCs and STs shall be taken into consideration consequently with the maintenance of efficiency of administration in the making of appointments to services and posts in connection with the affairs of union or state. Simply one line. It is not fixed. According to the time, whenever claim is made by SC and STs, if that claim is proper, if it is needed, reservation can be changed according to that. So they made it like flexible. Article 335 just made reservation for SC and STs flexible. That's all. You don't have to know all the 3 lines. It has to know, it doesn't have to be so big. Just simply 335 made the reservation process flexible. That's all. Next, something in the international relations. The first topic in international relations is the Masada Fortress. Paka prelims question. So where is the Masada Fortress? That's all. It's in Israel. Masada Fortress in Israel was illuminated with lights where both the Israel and Indian flags were together to celebrate the 30 years of diplomatic relations between India and Israel. Though India had recognized Israel in September 17, 1950, full-fledged diplomatic relations between the countries, it was established only in 1992. Until then there was no good diplomatic relations. Okay, only 1992 full-fledged relations were established, and now we know Israel is almost like an all-weather friend for India, and we have good foreign relations with India as of now. And the next one is Joint Military Cooperation Committee, JMMC. A direct prelims question. Joint Military Cooperation Committee is an allegiance between India and which country? Answer is Oman. So direct prelims question this is. So this is the highest forum of engagement between India and Oman. So JMMC is the highest forum of engagement between India and Oman. And something very specific is Oman is the only country in the Gulf region with which all three services, Army, Navy, Air Force, all the three services conduct regular bilateral exercises and also staff talks. Apart from this, Oman also provides critical operational support to Indian naval deployments in the Arabian Sea and also anti-piracy missions. So in the Gulf, so all the relations with India, the most highest relation is with Oman as far as defense ties are considered. And it is expected to meet annually. This JMMC is expected to meet annually, but could not be organized after 2018 when the 9th JMMC took place. So in 2018, the 9th JMMC took place. And now we have the next JMMC happening. So after a huge gap. Next is China-Taiwan relations. Recently, China flew some warplanes towards Taiwan. Normally, China does this once in a while to express a displeasure at something Taiwan has done or to show international support for the democratically ruled island. That is, if any other countries start supporting this Taiwan, which is now being democratically ruled, if they say we are going to recognize Taiwan, immediately China will do something like this to show a displeasure. Or if Taiwan does something wrong against this one China policy, again they will do something like this just to show a displeasure. So what is the story between China and Taiwan? Chinese civil war, it forced the defeated Kuomintang, or it is simply called as KMT. There was a civil war between KMT and the Communist Party of China. Actually at the beginning KMT was winning, but later on the Communist Party of China started to win, and the KMT party, they just fled to a small island nearby to China, which is called as Taiwan. And in between China and Taiwan, you have the Strait of Taiwan, which could be a prelims question. And this Kuomintang or NMT, they are also called as the nationalist. They escaped there in 1949, and since then they have been calling they are a democratic state. They also say actually that is what is the real China, and even today the huge China is called as Republic of China. But Taiwan claims they are the actual China also. And most of the international countries, they have not recognized Taiwan still because China is always opposing it. But recently, the European Union called for bolder actions to strengthen the European Union and Taiwan ties, because Taiwan faces pressure from Beijing. But European Union, they are trying to suppress China now. So they are trying to have very more ties with Taiwan. And Taiwan, it also has another name called Chinese Taipei. So in international games like Olympics and all such games, they compete with the name Chinese Taipei. And Taiwan does not have formal diplomatic ties with the European nations. As of now, they have diplomatic relations only with one tiny country called as the Vatican City. Apart from Vatican City, they don't have any proper diplomatic ties. But China, it says one country, two systems policy is being followed until today there, where Taiwan would have the right to run its own affairs. It is something similar to Hong Kong. Hong Kong got its independence from Britain in 1997, but they are not ready to join with China. They say we are even ready to be as the colony of Britain. We are ready to continue that, but we are not ready to be a part of China, because they fear the suppressive nature of China, the communist nature, suppressive nature of China. But they have, and of course Hong Kong has tasted democracy for a long time. They are not ready to be restricted. So similarly, Taiwan also follows the same policy with China. That is, until today they follow the policy called one country. China says Taiwan and China are one country, but there are two systems. Taiwan, it is not being a communist way of rule. It is a democratic country. They handle their own affairs. And as far as India-Taiwan relations are considered, there is no formal diplomatic ties, but Taiwan and India have been cooperating in various fields. India has refused to endorse the One China policy since 2010. Okay. Since there is rivalry growing between India and Taiwan, so India did not recognize this One China policy. It is all, they have not, of course, officially accepted Taiwan as a democratic separate country, but at the same time they have not accepted one China policy of China also. And that's it for today. Jai Hind. If you had found the content useful for you, share it with your friends as well. Let us learn and grow together.